a lack of therapy, and my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy mitigate, or excuse me, um, essentially bears on determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Leaf Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job, but it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to
No, I don't really. I'm
same?
trying to stay big picture, which is let's. What is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a picture, a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that um, Captain Winfrey, I don't know if she's still.
All right, guys, buckle up. This case starts with a shocking premise. A correctional officer accused of smuggling drugs into the very jail she worked at. From the jump, the stakes are high, but what really hooks you is a decision to represent herself. That choice alone sets the tone for everything that follows. You can already sense this won't be a normal trial. It's heading towards something chaotic, unpredictable, and possibly disastrous.
Or another employee there
that may have
did this
possibly
sexual assault?
that may have been the one to do. I don't know who the person was, but being
Where
that
did it occur?
I tried calling DoorDash to get in contact to see if I can get it because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
outside the jail, but I was working with Fulton County at the time.
All right. So the objection came. You were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have
Okay.
any reason to believe that he did?
Because if he's aware of the baby
Oh,
shower,
no, that's not my question. Not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from anybody. It could have came from Captain Winfrey, it could have came from Lieutenant Grady, it could have came from the
What
inmate.
could have come from them?
If someone, if my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail because they have a picture of my son. They have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father,
Okay, okay, I understand. So, any position of the state? I mean, I'm just trying to focus on process procedure here.
right.
The things that Miss Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay, I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about. Uh,
That is the person who threw the baby shower
The
initially.
person who's coming next.
Yes.
Okay, well, glad we're talking about it now then. All right, well, with I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think
Right.
the state's objection to facts, not in evidence.
All right, now we move into a completely different lane with the sponsor segment. While it doesn't connect to the courtroom drama, it's part of the full structure of the video. It shifts the tone away from tension into something more casual and promotional. For editing purposes, this section is optional, but if kept, it serves as a pacing break before diving into the legal chaos that unfolds right after.
What we'll be going back to the jury will be State's Exhibit 1, which is the oath. State's Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. State's Exhibit 12, which is the evidence log. State's Exhibits 22, which is the caduceus report. And State's Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back.
Yes, Your Honor.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a
Yeah.
copy of the oath?
If you've already got it, yeah, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office, I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else, not, I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I.
Now we're in the courtroom, and things immediately start getting interesting. The judge steps in to block the defendant from bringing up unrelated personal trauma, making it clear that this trial is about facts, not emotional narratives. This moment is critical. It shows a disconnect between what she thinks matters and what legally matters, setting the stage for repeated clashes with the court.
All right. Well, if that's all, the objection I'm hearing is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, State's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm gonna do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
Here's where things begin to spiral. The defendant launches into a confusing story involving threats, a baby shower, and a mysterious photo of her child. Instead of clarifying her defense, she creates more confusion. As a viewer, you're left trying to piece together what she's even claiming, and it becomes clear that her argument is slipping further away from anything grounded in reality.
Back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind, but otherwise all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments?
The judge tries to regain control and extract something coherent from her claims, but it's like chasing smoke. Simple questions about where and how events happened are met with vague, scattered answers. This moment highlights a key issue. Without clarity or focus, her defense is collapsing in real time, and the court is losing patience.
Just put some things on the record that we need.
I need paperwork out my bag, if that's possible. Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you can just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Prior Street, which is south of us, and made a left at Mitchell and Prior, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes. Your Honor.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting
And then comes a major blow to her credibility. After insisting on questioning a witness tied to her claims, she suddenly admits she has a wrong person. It's a jaw-dropping moment because it shows a complete lack of preparation. In a courtroom, mistakes like this aren't just embarrassing, they're damaging, and this one hits hard.
Of this trial. More to the present business at hand. No,
Excuse
it's
me.
not your turn, Miss Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record. Is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would
Because
be
you can't deny
no.
that injustice.
And that
Yeah.
I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum, are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no and then just reread the intent charge and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the.
Now we shift to evidence, and once again, her defense stumbles. She tries to challenge a document by questioning her own signature, but in doing so, she practically confirms its validity. It's one of those moments where the more she talks, the worse it gets. The judge shuts it down quickly, but the damage is already done.
All right. We're back on the record. I've been informed by Lieutenant Lattimore that the jury has reached a verdict, and Ms. Young is now present back in court. And Ms. Young, I will remind and direct you once again that there are not to be any verbal outbursts, and I'll allow you to perfect the record at the appropriate time, but that is only going to be when I call on you. So with that, we can bring in the jury. All jurors are present, Your Honor. Thank you, Lieutenant Lattimore. Please be seated, everyone. Members of the jury, I've been informed that y'all have been able to reach a verdict. And if that is the case, it appears that juror number 8 is our foreperson. All right, if you could hand that verdict form to the lieutenant so that I can take a look and make sure it's been completed. All right, and you can hand that back to our foreperson. And sir, if you could now publish the verdict in open court by reading it, you can remain seated and read it into the record.
Count one, possession of a Schedule 1 controlled substance with the intent to distribute, you find the defendant guilty. As to count 2, possession of a Schedule 1 controlled substance, we find the defendant guilty. As to count 3, crossing guard lines, we the jury find the defendant guilty. As to count 4, possession of a Schedule II controlled substance with intent to distribute, we, the jury, find the defendant guilty. As to count 5, possession of a Schedule II controlled substance, we, the jury, find the defendant guilty. As to count 6, crossing guard lines, we, the jury, find the defendant guilty. As to count 7, possession of a Schedule IV controlled substance with intent to distribute, we, the jury, find the defendant guilty. As to count 8, possession of a Schedule IV controlled substance, we, the jury, find the defendant guilty. As to count 9, crossing guard lines, we, the jury, find the defendant guilty. As to count 10, violation of oath by a public officer, we, the jury, find the defendant guilty.
And that has been signed, filled in, and dated by you.
Right.
All right. If you could hand that verdict form back to the deputy so that the state may review it as well as the defendant.
Oh, I've seen this.
All right. Starting with the state, is there any objection to the form of the verdict, and is there any reason this jury cannot be excused?
No objection, Your Honor.
All right. And over to Ms. Young. Any objection to the form of the verdict, and is there any reason this jury cannot be excused?
There's an object.
All
You're
right.
still in contempt of justice, but that's
As closing arguments approach, there's a brief calm before the storm. She insists on handling her own closing, which might sound bold, but given everything we've seen so far, it feels more like a setup for disaster. The judge lays out the process clearly, but you can sense that something is about to go very wrong.
Aggravation. Let's also start with your recommendation as well.
Your Honor, as the court is aware, the defendant, or the court may not be aware, but the defendant does not have a prior record. However, the state's recommendation in this case is not only based on the evidence in this case, but also based upon the fact that the defendant has not accepted responsibility for her actions and in the situation that she caused at the jail, and the fact that her actions potentially put inmates and other people at risk. For that reason, Your Honor, the state recommends the following sentence. With regards to counts 1 and 2, we believe count 2 would merge with count 1. The state's recommendations on counts 1 and 2 are 15 years to serve 10. State's recommendation on count 3 is 5 years to serve, concurrent with counts 1 and 2. Regarding counts 4 and 5, again, the possession in count 5 would merge with count 4. State's recommendation is 15 to serve 10. The recommendation for count 6 is 5 years to serve to run concurrent with counts 4 and 5. Count 7 and 8, Your Honor, the state would recommend 15 to serve 10, with count 8 merging into count 7. And on count 9, 5 years to serve to run concurrent. And then for the violation of oath, the state would recommend 5 years to serve.
And here it is, the turning point. The court reconvenes, and she's nowhere to be found. Minutes pass, and it becomes clear she didn't just step out, she left entirely. This is a massive moment because it changes everything. Trials don't stop for this, and now the case moves forward without her, putting her at a huge disadvantage.
Evidence in aggravation, Ms. Boykin. At a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang affiliation, that there were, and I know that there was a warrant taken out initially in this case about gang affiliation, and that he referenced other evidence showing that she was distributing directly to inmates. And so is that something the state is prepared to introduce in aggravation here today?
Your Honor, the state does have information related to that. We do not have the witness here to testify regarding those matters. Should the court hold a scheduling hearing or a hearing at a later date, we can have that witness available given this time of day.
All right, well, not hearing a request to continue sentencing and the evidence not.
Would request for the court to continue sentencing to hear from that witness.
And the state's recommendation, though, would remain the same after presenting this aggravating evidence.
It would, Your Honor.
All right. And just by, wouldn't consider it unless we did hear that evidence, but by way of proffer to complete the record, what would be your proffer, what that witness would testify to?
Your Honor, the witness, Raylene Bruce, would testify that she too worked at the Fulton County Sheriff's Department. She assisted Investigator Green with obtaining the defendant's cell phone. A subsequent dump of that cell phone did show that the defendant was communicating not only with inmates, but with other individuals to sell items, to sell drugs within the jail. There are also some Instagram postings for the defendant. And there are also photos of her gang tattoos that were taken at.
When she finally returns, the explanation doesn't help her case at all. Surveillance shows she walk away from a courthouse, and her reasoning, needing food and forgetting the time, falls flat. The judge isn't buying it, and this moment seals a critical shift. The court no longer trusts her to follow basic procedure.
To do so, this is an opportunity for you to tell me anything about yourself, your character, your background, anything that you think I should consider in mitigation, meaning why you deserve a lesser sentence and whatever sentence you recommend. And so to that end, the floor is yours.
So as I said earlier, on the record, we are in equity jurisdiction, correct? You have no answer?
I'll have an answer for you shortly, Ms. Young.
Okay. So, the failure or refusal to proceed in equity under exclusive jurisdiction will constitute in contempt of justice. As I said earlier, I was seeking administrative remedy, awaiting your communications to be delivered to correct parties. You are in contempt of justice by not allowing the surety, the implied surety, to produce this receipt of payment. So with that being said, my fee schedule will be on the record publicly soon, as soon as I can. But again, I have a 4-year-old son. Like I said, there was a lot of miscommunication. You have been in contact with my mother and my father without my knowledge, and they have miscommunicated the time that I was supposed to be back. I told them the situation. And as I was getting lunch and headed back to the courthouse where your officers intercepted, that's all that was being said. So, and I was not read my Miranda rights as well, just putting that on the record as well. And also to clarify again, the respondent had a duty to all complaints and questions because of the legal special relationship of the parties. By not responding to the respondent via the indictment, the true bill that was originally sent to the respondent, is in breach of trust because of the infant estate and duty of care associated therewith and thereto in an express trust. The court and its officials, the prosecutor or the plaintiff, being that the state cannot represent itself, obviously, our legal title holder of not only the express trust, but also the constructive trust, as now have been placed on the record. I share the same or similar name again as the named defendant in their case number 23 SC 192047. However, for clarification, I am not acting in the capacity as the named defendant. I am the beneficiary and equitable title holder. None of this information is foreign to the court. This matter must proceed in equity, and failure or refusal to proceed in equity under exclusive jurisdiction, which you said we are in, will constitute contempt of justice. I am appearing, especially and not generally. I'm trying to let you know that this case has been settled. And until that notice reaches you, Until I'm able to go do what I need to do to make sure your notice reaches you, I'm here. So again, I would like to seek administrative remedy, awaiting your communications to be delivered to the correct party.
This is where everything explodes. The judge revokes a bond, and she responds with sovereign citizen arguments that completely derail the courtroom. She talks about jurisdiction and contempt in ways that don't apply, interrupting repeatedly. The judge responds with back-to-back contempt rulings, and the situation spirals into pure chaos.
She's back in the detention area, and we have had a deputy go back with her. The deputy is holding a laptop, which is live streaming these proceedings in real time so that she can still hear the conclusion of the court sentence and the advisement of her rights, which is very important. To conclude, I think the heart of this case is the violation of oath by a public officer. So I'm going to have that as the lead count. So count 11 would be 5 years to serve. I'm also going to make a special note on this sentence that this sentence is not going to begin running until 40 days from today's date, and that it's going to be consecutive to the court's order of contempt, which has already been filed and was entered on today, January 28th. So count 11 would be 5 years to serve. From there, we return back to the top of the indictment, where the sentence would be 30 years to serve 15 years with the balance on probation. Strike that. That would be 30 years to serve 10 years with the balance on probation, which is to run consecutive to count 11. Count 2 merges into count 1. Count 3, crossing guidelines, would be 5 years to serve consecutive to count 11 and concurrent with count 1. Count 4, possession of a Schedule II controlled substance.
Finally, we reach the climax. The jury delivers its verdict, guilty on every single count. It's a complete collapse of her case. As sentencing begins, even more damaging details come out, including alleged gang ties and drug distribution. Despite everything, she continues her arguments, but at this point, the outcome is sealed. This is a consequence of everything we've just watched unfold.